In no order, let's start with contract litigation. Contract litigation is a dispute, obviously, between two parties that enter into presumably a written, but many times an oral agreement. I'm going to divide it between the entertainment world and the sports world. On the entertainment side, there's an entertainer, a band, a musician, an artist, as well as that person has an agent in many instances. That person has a business manager. That person may also have a manager. There's a, if you will, entourage, according to the HBO term, of people who actually follow the performer. Every one of those people presumably have an agreement with the performer. They are, if you will, the eyes and ears of the performer. They get the performer to the shows, they book the arrangements, the business manager counts the money and makes sure all the bills are paid. The agent does more than that, gets commercials, may even get memorabilia signings if it's in entertainment and sports industry. Those are all contractual relationships. Many a time, not too often, but many times those relationships go awry. Billy Joel is a primary example where he woke up one day and realized there was a lot of money taken out of his pocket, allegedly, and in fact proven over time. The other arena, the other area, if you will, are especially on the record side. If you leave the little entourage of the performer or the artist, you go to the record label. There are, for example, agreements between the recording artist and the label, be it a major label or an independent label. There are agreements between sometimes the majors and the independent labels. There are agreements between the recording artist and I'm speaking music here, but certainly we could talk TV or Broadway or movies. There are agreements between essentially that artist, whoever that nucleus is, and everyone, from the possibly from a landlord-tenant relationship where they may rent space to an agreement with a producer or director. In many instances, that artist or that athlete will form their own company to enter into those agreements. But those are all contracts. And you never know when those can go awry, but they do. They go awry. In the entertainment arena, the labels and the artists really had a form agreement over the years, in which the artist would sign up with a label saying he or she or it would perform 5 different albums, now CDs, and although still called albums in the agreements, and there would be an option by the company to it could exercise every time one of the albums was released. All types of disputes involving those agreements. They were generally over time they've nurtured into a form, but we're talking a 50, 60, 70-page form agreement, which talks about residual rights, talks about merchandising rights, talks about post-production rights, all kinds of rights and obligations which very well may be breached. On the sports side, you also have your agent, you have your manager, you have your business manager, and you have people, if you will, the entourage around the athlete. Many a times litigation results from breaches of agreement. For example, about 4 years ago, we represented Peyton Manning. Peyton Manning, those who know football know, and many of those who don't know football know, as a former MVP of the National Football League, quarterback for the Indianapolis Colts. Peyton decides to sign a few hundred autographs with a company by the name of Triumph Productions, Triumph Sports. Triumph Sports was run by, at the time, a guy named Michael Bertolini. Michael Bertolini was very much involved in the Pete Rose debacle involving baseball and whether Pete Rose bet on baseball, and Michael Bertolini was a good friend of Pete Rose as well as other athletes in the industry. Well, Peyton signs autographs. Bertolini and or Triumph Sports decide they don't have the money to pay Peyton. What does Peyton do? He agreed to a price per autograph. I'm not sure what the price was. He was owed about $150,000, $125,000, $150,000. Peyton had an agreement. He had to sue. We sue, take depositions, move for summary judgment. We win because they really didn't have much of a defense, and we collect. And that is a, if you will, typical contract dispute between an athlete and a memorabilia company. Other contractual disputes between athletes and memorabilia companies, which appears to be where a lot of the business is where an athlete says, "That's not my autograph." Evander Holyfield, "That's not my autograph," he tells the memorabilia company. We have to litigate that.